5 seconds to go. Start. The scope of Section 141 of NI Act was again exhaustively considered by this court in SMS Pharmaceuticals Supra. What is required is that the persons who are sought to be made criminally liable under Section 141 should be at the time the offence was committed in charge of and responsible to the company for the conduct of the business of the company. Every person connected with the company shall not fall within the ambit of the provision. It is only those persons who were in charge of and responsible for conduct of business of the company at the time of commission of an offence who will be liable for criminal action. It follows from this that if a director of a company who was not in charge of and was not responsible for the conduct of the business of the company at the relevant time will not be liable under the provision. The liability arises from being in charge of and responsible for conduct of business of the company at the relevant time when the offence was committed and not on the basis of merely holding a designation or office in a company. Conversely, a person not holding any office or designation in a company may be liable if he satisfies the main requirement of being in charge of and responsible for conduct of business of a company at the relevant time. Liability depends on the role one plays in the affairs of a company and not on designation or status. If being a director or manager or secretary was enough to cast criminal liability, the section would have said so. Instead of every person, the section would have said every director, manager, or secretary in a company is liable, etc. The legislature is aware that it is a case of criminal liability, which means serious consequences so far as the person sought to be made liable is concerned. Therefore, only persons who can be said to be connected with the commission of a crime at the relevant time have been subjected to. To sum up, there is almost unanimous judicial opinion that necessary averments ought to be contained in a complaint before a person can be subjected to criminal process. A liability under Section 141 of the Act is sought to be fastened vicariously on a person connected with a company, the principal accused being the company itself. It is a departure from the rule in criminal law against vicarious liability. A clear case should be spelled out in the complaint against the person sought to be made liable. Section 141 of the Act contains the requirements for making a person liable under the said provision. That the respondent falls within the parameters of Section 141 has to be spelled out. A complaint has to be examined by the magistrate in the first instance on the basis of averments contained therein. If the magistrate is satisfied that there are averments which bring the case within Section 141, he would issue the process. We have seen that merely being described as a director in a company is not sufficient to satisfy the requirement of Section 141. Even a non-director can be liable under Section 141 of the Act. The averments in the complaint would also serve the purpose that the person sought to be made liable would know what is the case which is alleged against him. This will enable him to meet the case at the trial. Coming to the facts of the present case at hand, a perusal of the complaint filed as Annexure P1 clearly goes to establish two facts. The description of the respondent accused contained in the complaint is as under. From the aforesaid, it is clear that though the respondent accused was described as a director of Ravi Organics Limited, but the company itself was not arrayed as a party in the complaint. A perusal of the averments made in the complaint goes to show beyond a shadow of doubt that there are no averments that respondent number 2 at the time when the offence was committed was in charge of and was responsible to the company for the conduct of the business of the company. This court has been firm with the stand that if the complainant fails to make specific averments against the company in the complaint for the commission of an offence under section 138 of NI Act, the same cannot be rectified by taking recourse to general principles of criminal jurisprudence. Needless to say, the provisions of Section 141 impose vicarious liability by deeming fiction which presupposes and requires the commission of the offence by the company or firm. Therefore, unless the company or firm has committed the offence as a principal accused, the persons mentioned in subsection 1 and 2 would not be liable to be convicted on the basis of the principles of vicarious liability. Reference in this connection may also be made to another judgment of the two-judge bench of this court in Himanshu versus B. Shivamurthy and another Supra, the facts wherein have a stark similarity to the facts of the present case, considering the issue where the complaint was lodged only against the director without arraigning the company as an accused, and whether the company could be subsequently arraigned as an accused, it was observed as under. Stop.